I would ask Gönenç Gürkaynak, and apologies if I'm not pronouncing. Okay, thank you. He's the founding partner of ELIG Gürkaynak Attorneys at Law, one of the leading firms in Turkey, Istanbul, Turkey, with 95 lawyers. He's a graduate of both Ankara University and of Harvard Law. And he holds quite a number of bar memberships in several countries. And so very well placed to tell us a little bit about also the international scope of this entire movement. So, Gönenç, thank you.
Very kind of you. Thank you. I was asked to take a look at sustainability issues in my first round, at least, and merger control and sustainability. Which is interesting because sustainability has made heavy inroads into the public policy thinking everywhere. And obviously one question that one has to respond to before engaging in sustainability and merger control type thinking is there really a possibility for furthering consumer welfare, maximizing consumer welfare through merger control that is cognizant of particular sustainability goals? Or are we quoting sustainability because that's the hip thing to do these days? I'm raising this flag because it seems that there is an underlying current of a belief that actually there is no business demand for a more lenient approach on sustainability matters. Actually, there's no demand from businesses, neither on the enforcement side for behavioral matters, nor in terms of merger control, a recognition of sustainability being a particular separate topic. This may not be entirely true. In the enforcement side of things, which I won't get into, it is becoming clearer and clearer that actually businesses do take a step back out of fears of antitrust enforcement, and they don't do the exact amount of good that they can do that would further sustainability goals in certain concrete cases because their legal advisors are rightfully telling them that what they're intending to do may amount to a competition law violation. So there is a demand there. I'm not only talking about the more slam dunk cases that have been coming in from 2015, but I'm also talking about very recent developments in removal of CO2 in the North Sea by a few oil and gas manufacturer companies jointly. Can they do it jointly? Should they be allowed to exchange this information and all that? Because it's not merger control, I'm leaving that. But the reason why I went into it very quickly as a quote-unquote quick look test was because I wanted to show that there is an interface between sustainability and competition law in that field. Now the question is it also a matter of merger control? And I would respectfully contend that it is, and there is merger control effort that needs to be spent, particularly cognizant of the developments in the sustainability field as well. We could go two ways. Either it's going to be following the journey of the efficiency defenses and particularly the innovation bit. So we're going to pay a lot of lip service to it for a few years, and innovation, yes, it's very important, but actually it won't make a difference in the holding of a case for a very long time, but we will pay lip service to it, and then slowly it's going to become a thing in actual enforcement, and we will be able to say, aha, this case was going to go this way, but it is now going that way because of innovation worries, as it's happening today, finally. Is it going to be the journey of sustainability as well is an important question, because the one thing that we don't have in the sustainability analysis is time. None of us do. No human being has time when it comes to the sustainability matter. So could we progress with the learnings of what we have learned through innovation? Could we progress into a quicker adoption beyond paying lip service to it of sustainability goals in the merger control field as well? And that begs for another question, which is, could we be looking at antitrust authorities being only too keen on articulating fears, but not being so keen on accepting defenses under the same heading. So when innovation is a matter of fear, when there are concerns about innovation, it always becomes articulable, as you know, and it is very quick. The Dow DuPont type of approach happens seamlessly. But when entities come in and defend their cases and say, here are the innovation gains, then typically they get discounted as this is speculative, it's not very calculable, we can't touch it. So what the authorities can more naturally touch is the concern and not the forward-looking statements of the businesses. If the same thing were to happen in sustainability, that would be a disaster, because the businesses know best actually as to where they're trying to go. And the antitrust authorities, by definition, they're not masters of how the products are going to evolve and what the customer demand is. But at the same time, obviously, they can't give a carte blanche and they can't show full deference to what the businesses are selling to them, because businesses are also known to sell them things that are not true. So how do we strike the balance? By start working on that, and by recognizing that in the merger control field there is a sustainability issue as well. We have seen it in Bayer Monsanto in Europe. The transaction was formed to steer farmers into unsustainable industrial agricultural methods. This was articulated as a fear in Bayer Monsanto. The potential to steer farmers into unsustainable industrial agricultural methods. Now, this is admirable, but at the same time, any learned competition lawyer would start getting a bit jittery that, you know, are we engaging in scaremongering here? Are we engaging in too speculative an articulation of theory of harm? How is this, how is this something that we can put forward as an economic model? The possibility that farmers may be steered into unsustainable industrial agricultural methods. But then again, if you don't go into that kind of soft language, and if you want everything to be quantifiable, then you're probably going to miss the train, and you're probably going to not come up with the type of social good that you could. That I am only able to articulate as a catch-22, as a dilemma at the moment, but not as something the solution of which is known to me. It is very interesting as a technique to observe that antitrust agencies all around the world, and this time around we could include the US agencies as well, are tending to define relevant product markets separately for some sustainable products, which could arguably be substitutable with their next kin that is more traditional as a product. In the aluminum automotive body sheets material in Aleris Novelis, very recent case, the European Commission said, well, this is separate from the other aluminum products that could normally be a substitution for what these two companies are producing. It could be substituted, but this is used in fuel-efficient cars that have low emissions, and for that purpose, I'm defining a separate market for it. Now, this is a double-edged sword as well. Sometimes we see this as the approach in the United States as well, the separation of the two markets. On one hand, it's admirable and good to protect these as separate markets. On the other hand, it might mean that businesses may not be as enthusiastic to go into these particular fields, because these are becoming roadblocks in bigger transactions and bigger schemes. It's interesting to observe, and I will use just 2 more minutes of time if I have. Yeah. In Orbis Metallo in 2020, we see concerns of reduction of incentives for recyclers to collect and sort copper scrap, which is an electric vehicle component, as a concern. I'm also trying to throw as many cases as possible at you because these are really new stuff, and I know that some people might be working on these topics, and one thing that we really direly need is for this field, i.e. the interface between merger control and sustainability, to be recognized as a bona fide field to start with. So there are things happening, is what I'm trying to say. And the CMA in the UK, in the Vela Suez case, that you could say is still ongoing, so a case of 2022 basically, says that I have risks of loss of competition which could reduce innovation to achieve net zero emissions. And the innovation to achieve net zero emissions is particularly dear to my heart, and the innovation effects or the stifling of innovation in that particular realm is going to be a particular source of worry for me, is what the CMA is saying. I have tried to also show that innovation issues and sustainability goals go hand in hand. And we've already fallen into some pitfalls in the journey of the handling of innovation as a source of dynamic efficiency, hence a target in terms of economic efficiency enhancing social welfare. So we might perhaps start by recognizing that sustainability is naturally a part of the welfare function. There's no discussing whether this falls within the objectives of competition law, and any midterm welfare maximization goal will naturally have to contain an element of sustainability, seamlessly maybe, but still it's there. Thank you.
Okay, so to recap, two questions, one more about the investment banking angle, the one about the economics underpinning of merger policy, whether that may be lost in the process in here. Any comments?
Yeah, it's interesting. So other jurisdictions do look up or look toward the U.S. antitrust enforcement, definitely. I don't want to be shamelessly pushing some articles that I have been publishing. In 2014, I had written an article and published at the Journal of Competition Law and Economics of Oxford University Press that analyzes emerging markets and U.S. horizontal merger guidelines. And in that, I was actually advocating that U.S. has been a role model for such a long time, but now is the time that emerging markets should cut their umbilical cord and try to find their own ways, because U.S. is now, as of 2014, with the guidelines, going toward a more case-by-case basis kind of analysis, and there are less of bright line rules now, and they're well equipped to do this because they do very sophisticated economic analysis. But if emerging markets were to try to follow that suit because they have memorized the reflexes of following the US, then this is going to be disaster, because the emerging markets competition agencies don't have the same depth of economic analysis, so it's just going to be basically saying yay to whatever the US says without understanding the particulars of it. A lot has changed since, and now we're discussing again, actually bright lines aren't that bad, and we should have some bright line rules and rules of thumb. And I do agree, by the way, that so long as a Supreme Court ruling is good law, it'll have to be followed. But I'll say that it is quite an interesting predicament that intellectually people might be interested in noting that not only emerging markets, but a lot of jurisdictions are checking what's happening in the US so much that this is a collateral thing that needs to be thought about. It can't be a determining thing in taking policy actions, because you're obviously more interested in what is happening in your own soil to your own people, and if it has unintended impact on other jurisdictions, that's just unfortunate or fortunate depending on the outcome. But it needs to be noted. It needs to be known, and I think the use of more obvious principles in the U.S. does benefit the global development of competition law in general. Very quickly on the point of investment bankers check, because I'm a private practitioner here as well, so you might want to hear about that. Investment bankers do check, it's true. In the US, the transactions are even more sophisticated, so there's a deeper check. Here, when I was practicing here, already the prep work was quite a bit of the work. In Europe and in the UK, somewhat. But in Europe and in the UK, the feeling you get is they're trying to mark the roadblocks, but they will want you to say, we can overcome this. And it's the investment banker attitude anyway, to push, push, push. So basically, it very rarely comes down to no can do. And it very frequently comes down to how can we fix this? What kind of a commitment could be given along the way if they were to take issue? Let's play coy first and do a standard filing. If they flag something, then we'll jump on it and all that. Which doesn't really wonderfully work in the US, particularly because you end up litigating. So that's why a deeper check is done in the US, I presume.